Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here each and every week at this time on this station. At this time on this station each week. Tune in where I'm going to bring you the valuable information that you need regarding natural gas development in Pennsylvania. I am Attorney Doug Clark of the Clark Law Firm. I do not, and I will not represent gas or pipeline companies. I represent Pennsylvania property owners, Pennsylvania oil and gas right owners. Never have represented the company, and listen to me, check out the websites, hear how many times I say it, and I mean it. I never ever will. I represent the Pennsylvania landowner because we need to get this information to the landowner, to the oil and gas right owner, to make sure that you are not being taken advantage of by a multi-billion-dollar company. We need to do what we can to even the playing field. They got enough lawyers working for them. We need to have experienced lawyers working for you who are out for your best interest, not the company's interest, but your best interest. And I can tell you this, I'm already fired up today, and I love this subject because something happened this week, a classic thing. You know, it happens every once in a while. I get this call, and let's go hypothetical. Okay, we're going to make this a hypothetical because I don't want to disclose any specific individual facts. So I'm going to change it up a little bit, but you're going to understand the point, I promise you. So let's say that you entered into a pipeline right-of-way option agreement. Now that means, in general, that there is a time frame in which the company has to do what is called exercise the option, saying, okay, we are going to install this pipeline right-of-way agreement. Now, when they're going to exercise the option, they have to do something. Now, different agreements have different requirements to exercise an option. It may be they have to send you a letter and say, hey, we're going to exercise the option. It may be that they have to send you a check for what you had bargained for in your original agreement to say, here's the notice, we are going to exercise the option, and we're going to install the pipeline, and here is the check that we owe you upon exercising the option. Now, ladies and gentlemen, if you didn't negotiate your agreement, you may not be getting a check at that point. I'm not going to go down this path too far, but I'm going to say this. If you are signing a pipeline right-of-way agreement without speaking to a knowledgeable attorney, whether it's me, and I'd love for you to give us a call because I really want to even this playing field. And I want to tell you what you need to know, not what the company wants you to know, what you need to know. But if you don't call me, call someone, an attorney who is knowledgeable, that you have confidence in, that is going to work for you. Quick side, I do these reviews and consultations. So if you're thinking, you're like, hey, I'm about to sign this document, I encourage you, I'm going to be commercial. I encourage you, call the office, call the Clark Law Firm. I don't care where you are, as long as the property is in Pennsylvania. We have clients all across the state and who live across the country who have property rights or gas rights in Pennsylvania. Do not be afraid of distance. Give us a call, 570-307-0702. And if you miss that number, I'll say it in the commercials and some other times probably, but give us a call before you sign. Give us a call, 570-307-0702. Learn what we do. If nothing else, I would encourage you to explore the idea of doing a review and consultation where I would review your pipeline right-of-way agreement. You send it to us. We do them by telephone all the time, but you can also do it in office. You send it to us. I'll review it. We'll have a call, and we can have multiple people. If multiple people own the property, we can have them on the call as well, and I will explain in detail your leverage, your ability to negotiate. I will explain in detail what is good about this agreement and what is bad about this agreement. I will give you, again, what you need to know. I will also most likely have negotiated with that company in the past and can also tell you additional terms or language that you can probably get that will be very beneficial to you. I will also, again, as we discuss leverage, talk about the potential of getting more compensation or more money. It is not an exaggeration that I have represented people who have been offered $20,000, $30,000 or less who have signed for over $100,000 or even $200,000 and more. That's not an exaggeration. That's not saying it's going to happen in every case, but I assure you it has happened. I have had clients sign right-of-ways for literally over $1,000 per foot. I have had many clients sign right-of-way agreements for over $100 per foot. I'm not saying this because I'm some kind of genius and great, wonderful lawyer guy with some huge ego. I'm saying it because it's true. And if those people didn't call me or somebody who knew what they were doing, and they weren't advised of what their leverage was and their ability to negotiate and evaluate their leverage as to what they could do, those people might have got as little as $15 a foot or $25 or $30, but they didn't. They understood, hey, look, the landman works for the company, not me, the landowner. The landman who works for the company is not going to tell me the information that I need to know where I may have some hidden leverage and ability to negotiate. That, ladies and gentlemen, is not their job. That is not their job. Their job is to get you to sign. That's their job. Not to tell you all of your different rights and your leverage and all the different terms that you could have and the potential ability to negotiate more money. Their job is to get you to sign. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Join me right here each and every week at this time on this station. Every week at this time on this station, you can always call the office about representation, learn more about representation, learn more about reviews and consultations, 570-307-0702. Okay, back at it. So landman works for the company, not you, the landowner. So let's get back to the option agreement. So we're talking about a pipeline option agreement. They occur all across Pennsylvania. You've heard me say before, and this is so important, I have reviewed, consulted on, or negotiated on pipeline right-of-way agreements with over 70 different companies. I say that again to give you an idea of the experience. Not to say again, oh, this guy thinks he's so great. That's not what I'm saying. I'm saying that there is information and a wealth of knowledge that we have on our side that goes so far beyond, well, Mr. Smith down the road signed the agreement and I should too. And what got me all fired up again this week is when people call in and they say, yeah, I signed for $15 a foot because the landman told me that's all the company was going to pay, that's all they pay. Well, let's get them to put that under oath and see how that works. But then also, think about this. This is what you have to know. And look, I see it all the time. What happens is there are two types of payments for pipeline right-of-way agreements. One is what they call compensation. And what companies will do, and please pay attention, this is lifting the veil, pushing aside the curtain to find out what really happens in many cases. This is the truth. This is what happens in many cases. I have seen it many, many times. So, landman says, all we pay is $15 a foot. Well, maybe that might be true. Maybe that might be true. But that doesn't cover the second part of it, being the damages. So There's companies out there that routinely will pay the landowner $15 or $30 a foot, or whatever that standard price is that they then preach, well, this is all we pay. This is the most we've ever paid. This is the most we've ever paid. They know what's going to give you some assurance or make you feel better. Okay, I'll sign because that's the most they've ever paid. Well, they don't tell you that they may have paid somebody significantly more money in what are called damages payments. So you have two types of payments. You have compensation, where companies tend to like to say things like, all we pay is $30 a foot. That's the most we've ever paid. But they don't tell you about the damages payment. And I've done agreements where the payment per foot is, say, $30 because that's what the company routinely and always pays. But we wanted to get, say, $60 a foot or $80 a foot. And we were able to do that. But the company says, hey, look, Doug Clark, we don't want to say $60 a foot in compensation or $80 a foot because, and they don't say this, but because they're out there telling everybody they've never paid more than $30 a foot. So they say, we can meet your price, but we have to dedicate or allot or direct the other $30 a foot. We'll put $30 a foot towards compensation so we can continue to tell everybody that that's all we've ever paid. But, hey, Doug, we'll put another $30 a foot and we'll categorize that as damages for things like crops and timber, even if there isn't crops and timber even there. So we can continue. We can continue our, what I would say is a false narrative, but we can continue our narrative to the local landowners that we don't pay more than $30 a foot. Well, yeah, that's in compensation, but in damages, you have paid, when you combine it, maybe more than $100 a foot in many, many cases. But they get to sit there at your kitchen table and say, oh, all we pay is $15, $30, whatever that number is, per foot, and they don't talk about the damages payment. It happens all the time. And you don't know about it unless you're talking to somebody who knows what they're doing, who knows it from your side and knows what you need to know. If you're going to rely on the landman who works for the company, you're going to hear all we ever paid, the most we ever paid was $30 a foot or $15, whatever that number is. Ask them, well, how about with compensation combined with damages? Have you ever paid more? And then see if they start stumbling. Well, or they say, well, yeah, well, it depends. See what they say. But I'm going to tell you, I would be willing to bet that almost or every company has paid more than what they're representing because they're hiding from you. They're not telling you. They're not giving you that information, in my opinion, that you need to know that there's other ways that you can get higher compensation. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. We're coming up against our first break, as you can tell, and I'm excited about this because I want this information out there. What I'm going to talk about, I'm going to keep talking about this, but just here's our little teaser coming into the next section or segment. When the landman says to you that that's all we're paying, that's the most we've ever paid, think about the gas leases and think about what you signed for, you yourself, and when you signed. And did that landman tell you that this was the highest they were going to pay? That this was the most that they've ever paid? They can't believe they're paying this much. Doug Clark, said in the meeting in, I think it was December, maybe it was November of 2007, where the landman said, we're paying $750 an acre, 12.5% royalty, and I don't know what the company is doing. They're crazy. I can't believe they're paying this much. I have been in this business for 20 years, and I've never seen anything like it. They're so overpaying. This is a gift to you. I was in the room. And what happened? 3-4 months later, 5 months later, offers were $2,500, $3,000, Later that year, $5,000, $6,000, 21%. So think about that. So just again, think about, what were you told when you signed your gas lease? Were you told, listen, don't sign because we're going to pay more in a few months from now? No, you weren't told that. You were told, this is the most we've ever paid. This is amazing. You should take this. This is the most we ever paid. This is free money. Royalties where the money's at. Royalties where the money at. Well, who's seeing that so far? Some are. Many, many aren't. So think about that. And you don't stick your hand on that hot burner and say, wow, that was really hot. I burned my hand really badly. And then go back a couple years later and say, you know what? I'm going to put my hand on that hot burner again, because this time I think the result will be different. Well, when the landman tells you on a pipeline agreement or any other type of an agreement, this is all we pay, this is the most we've ever paid. Look, maybe it's true, but maybe you're getting the same information that you received when you signed your gas lease. Let's be smart. Let's make sure we're educated and informed. And whether that's coming through my Office of Representation, through the radio show, through our websites, through Penn State's websites, through another attorney who knows what they're doing, let's get that information. We need to have the people of Pennsylvania, we need to stop signing bad agreements and not be taken advantage of. And we're letting it happen, in my opinion, and we got to stop it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're just getting started. 3 more segments. Join me each week at this time on this station. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can call us 570-307-0702. And if you have an oil and gas issue, really recommend give us a call, see if we can help you and if we're right for you. And you need to be comfortable with your lawyer. You need to have the right person for you. I represent landowners, property owners, oil and gas right owners, gas lease negotiations, gas lease reviews and consultations, pipeline right-of-way agreements, unitization issues, royalty issues, buying and selling oil and gas rights. I've been doing shows on that recently. If you are selling your oil and gas rights, call us and do a review and consultation first. We do those, and I'm telling you, they are super valuable, and every person that has done one has left saying, wow, we're glad we did this. So if you're thinking about selling, before you sign, call, learn about your rights, learn about the pitfalls. There are often super huge canyon-sized loopholes in these agreements that are sent to you in the mail to buy your gas rights. Don't fall into that trap without understanding the transaction. Those documents need to be negotiated and they need to be changed, and there may be opportunities to get much more money, and most importantly, maybe this is a bad decision and you need to have all the information to think about what's right for you. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station. If you're new to the show, I've been doing the show for over 7 years now. I've been doing All Things Marcellus for over 7 years. You can go to the websites, pagasleaseattorney.com. That's pagasleaseattorney.com. And the sister site, pipelineattorney.com. If you have a gas lease, pipeline agreement, or any oil and gas issue, I would strongly encourage you check out the websites, pagasleaseattorney.com, pipelineattorney.com. Whether you ever call us, use the sites as a resource. We certainly would love to hear from you, but use the sites as a resource. Not specific advice for anybody, but a resource to get you thinking what you should be thinking about. There are all kinds of different sections on the websites. Check them out. I think they're good. I wrote them. So check it out, whether you're looking for representation or not. Check it out. And also, today's show will be up tomorrow, Monday morning. You can listen to today's show on either PA Gas Lease or PipelineAttorney.com, as well as many, many hours upon hours of other shows covering all different topics. So check out PAGasLeaseAttorney.com and PipelineAttorney.com and tune in each week at this time on this station. because we're, again, 7 years running and we're just getting started. So back to pipeline right-of-way option agreements. Okay. You need to understand what they are. You enter into a pipeline right-of-way agreement, and almost all of them are option agreements, meaning that the company gives you a certain amount of money up front. Could be $100, $500, $600, whatever that number is. You, ladies and gentlemen, typically can negotiate that number. So, wouldn't it be better to have $2,000 up front instead of $200? You can negotiate that number. Now, you may not always get it to move, but I can tell you that I've negotiated that number to increase by thousands of dollars easily 100 times or more. So, you want to negotiate that number. You want to also have the shortest possible option term. If you're agreeing to an option agreement, and it has an option term of more than 2 years, in my opinion, in Doug Clark's opinion, that is a big mistake. If you're signing an option agreement and it has a term of 5 years, that is a crazy mistake. But if the landman says, oh, well, that's what we do. That's how we do all of them. Oh, okay. Well, if that's what you do, then let me go ahead and sign. Think about that. If that's what they do, that's our new standard. Well, what do you do? Oh, so this is what you do to everybody? Okay, so now I want you to do that to me. Just think about how that goes. Just think about that. It's crazy. So no, we don't care what you say, because we know that other people have said the same things about gas leases and pipelines and all these other things. I can't tell you how many times we've submitted counter numbers on pipeline agreements, and the company says, oh, yeah, that's crazy. That's too much money. That's too much money. And then, lo and behold, they come back and they agree to that money. Not every time. And that's all part of this detailed leverage analysis, to look at your situation, to understand your situation, and to assess your leverage and how to approach future negotiations. That's all part of that process for specific advice, not general advice, but specific advice for you. So, what is the company going to say? Oh, sure, if you hold on for a little bit, well, if you counter for $50 a foot instead of the $15, yeah, we'll pay you more. No, they work for the company. They're going to say, well, they're not going to agree to that. They're not going to agree to that. They're not going to agree to that. Of course, that's what they're going to say. You say, well, all right, well, if they've never done it, well, why call an attorney? Why try to do anything? That's all they're going to do. They've won. They've now won. They've won. And remember this too. I can't say this enough. Basic economics. And I mean, you don't even need to know anything about economics, because, not that I know a lot about it, but I know this. I know the whole concept of supply and demand. And that's all we need to know when we're talking about this. So when a company says, we're paying $15 a foot and that's all we're paying, when a company says that, well, here's the deal. If everybody in that area, let's say this company is Howard Energy, and they're operating, let's say, in Tioga County, and they tell everybody, most we pay, all we're going to pay, again, hypothetically, we'll say $15. Well, the market is, and the truth is, if they're paying $15, it's because that's what the people in that county, and let's say Tioga in this example, that's what they're signing for. If everybody in Tioga who is presented with a pipeline right-of-way agreement from any company, for example, Howard Energy, Shell, any company, if everybody said, we're going to stop signing for $15, if that's the number, we're going to stop because that's too low. Because we know in Susquehanna County, they're signing for $30, generally minimum guaranteed. Minimum for one line. So we've come hip to this situation. So we're not going to do this. We're not going to sign what we think are bad agreements for bad compensation amounts. We're not going to do it. Then what is going to happen? And I'm going to guarantee that if everybody in the county said we're going to stop signing, say, at $15 a foot, what will happen is everybody will be offered more money. It is that simple. The reason any company is limiting payment to, say, $15 a foot, it's because they're doing a good sales job out on the street, out in the farms. They're selling people on, this is all we're doing, this is all we're doing. Well, if people said, well, look, that ain't enough. That's not enough. They would pay more. If you're a regular listener, you've heard this history. I'm going to be brief on it, and we'll be quick. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, Susquehanna County, they started the same way, $15 a foot. And ladies and gentlemen in Tioga, in Lycoming, in Potter, and all the other counties, they started at $15 a foot. And they said, shockingly, they said to me and they said to my clients, we're paying $15 a foot. It's all we pay. It's the most we've ever paid. It's all we pay. Then they signed everybody who would sign at $15 a foot. And then what did they do? People didn't sign anymore. They said, you know what? $15 a foot isn't enough for me. Well, that's all we paid. That's what your neighbor paid. Well, that's what we paid your neighbor. Well, that's fine. I'm not my neighbor, and I'm not going to do this for $15 a foot. So once they picked the low-hanging fruit, every person who would sign at $15 a foot that they could get in their plans, then what did they do? They raised the price. It went from like $15 to $25 or $30 in a blink of an eye. If you talked to the landman the previous day, you would have heard the most we ever pay is $15 a foot. The next day, they said, and I remember the conversation when one of the guys called to say, oh, hey, great news. We've increased to 20, I think it was 25 at the time. But what I remember more is he said, yeah, that's really more in line to what the market should be. And, people really should be getting that. And $15 was kind of low and 25 is more reasonable. Well, then what in the heck did you do for the last, year or two or however long, signing people with what you thought was too low of a number? Well, of course, you're in business to make money. We understand that. So if people are going to sign at $15 a foot, and if people are going to believe that that's all you're ever going to pay, or that you've never paid higher, and you can get those people to sign at $15 a foot, who in the world would pay $30 a foot? Nobody. So this is a calculated plan, my opinion, but I believe in it. It's a calculated plan to make sure they're paying you the lowest possible amount of money. It's calculated, shockingly, to make sure that you're going to get the lowest amount of money. And they're really good at it. And we need to understand that, and we need to confront that. And we need to understand your leverage. And I'm going to tell you, at $15 a foot, at a mere $15 a foot, I would take the pipeline right of way on my neighbor and not get that money every single time. Every single time. Because remember back when the landman said, well, royalties, that's where the money is, royalties. Well, listen, if you have a gas lease and you're in a gas producing area, you're going to get royalties. And if you only have an acre, then you're not going to have much pipeline anyway. Your royalties should so far beyond make up for having a pipeline on your property at $15 a foot, to have that burden there forever, to have the potential to have another pipeline, to have a third pipeline, to have electric lines, fiber optic lines, to have people driving all over your property for a one-time payment of $15 a foot, which you're going to pay taxes on. Thank you, but no thank you. Go ahead, put it on my neighbor, and listen, they have these leases. Think about this too, guys. They have all these leases, and they paid money for them. They don't want these leases to expire. These pipelines will be built. These pipelines will be built. Are you going to agree to have them built at $15 a foot? Or are you going to push and make sure that you get a more appropriate and fair compensation? They're going to be built. I had a client once get a pipeline agreement payment of $750,000 for a pipeline. It was, I think, approximately, it was way less than 900 feet, and I think it was less than 800 feet. And I say this not because, again, oh yeah, look at this guy, he's trying to brag about what he did. No, I'm saying that these pipelines will be built. And this guy would have been offered something like $30 a foot. I mean, a few $1,000s. And he signed for $750,000. $750,000. Obviously, it doesn't happen all the time. But what does happen all the time is compensation increases. And what happens all the time is that language, terms, and protections are added to that agreement. I do not recall a single pipeline that I've ever worked on, and I've worked on a ton, that we did not significantly improve the language of the agreement. Most cases, we're able to get more money, not every single one, but I can't think of a case where we did not significantly improve that document to protect the landowner. We're up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. If you have a pipeline right-of-way agreement, I'm going to talk more about this too. If you have a pipeline right-of-way agreement and that agreement had an option, and that option was recently or any time in the past year or two exercised by Howard Energy, call the office. We'd like to look at it to make sure it was done properly. Give us a call, 570-307-0702. I'm going to talk about that more towards the end. But remember this, Howard Energy option, if that occurred, give us a call. We want to make sure it was exercised appropriately, because if it wasn't, you may have a very, very powerful bite, a second bite at the apple. 570-307-0702. And remember, tune in with me, Doug Clark, from the Clark Law Firm, to All Things Marcellus each and every week at this time on this station. 2 more segments to go. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each week at this time on this station for All Things Marcellus. And if you can't join us each and every week, go to the websites pagasleaseattorney.com, pipelineattorney.com. If you're new to the show, or if you haven't been to the websites, go to pipelineattorney.com and pagasleaseattorney.com. Today's show will be up Monday. Every show that we've done, I think in the last year or two, is up and available. And I've been doing the show for 7 years, and we're not stopping because there is too much information that we still need to get out there. Way too much information. I represent landowners, property owners, and gas right owners. I have not, do not, and will not represent gas or pipeline companies. If you're looking for representation, give us a call, reviews, consultations, 570-307-0702. Okay, back to these pipeline right-of-way agreements. If you take, well, I don't want you to take one thing from today's show. I want you to take a bunch of things from today's show. But I'll tell you something I really hope you take. These agreements must be negotiated. And what you should do, in my opinion, I would highly recommend a review and consultation. Well, of course he does, because he's a lawyer. He wants to make money. He wants you to call him. I highly recommend a review and consultation. Yes, it's a service that we provide, and we charge for the service. It usually takes 1 to 2 hours, and I am very confident that you will have so much more information that's going to be very valuable to you to help guide you in what you want to do and how to move forward. This is what we do. It's what I do. I do these all the time. I do them for people in southwestern Pennsylvania, Fayette, Westmoreland, Greene, Washington, Armstrong, Butler, and on and on and on. I do them in Potter, Tioga, Lycoming, Bradford, Susquehanna, on and on and on. Give us a call, learn about the service. I really am confident that it can help you. I don't care what the agreement is, gas lease, pipeline agreement. listen to this word, please, too, extensions of any agreement. If they want to extend your gas lease, if they want to extend your pipeline right-of-way agreement, think Howard Energy, think anyone, though. If they want to extend your pipeline right-of-way agreement, your gas lease, or any other agreement, this may be your chance to correct any mistake that you made the first time. This may be your chance at a second bite of the apple, and this time that apple may be much juicier because they already have routes approved, and if they need to extend you, you may be in a very unique situation where you have significantly more leverage than what you think. And I will bet that they're not going to tell you that. Now, again, this is not specific advice. My advice would be do a review and consultation with me, call an attorney who knows what they're doing, but get the information and understand your situation. I have somebody now that we're going to do an extension on that I know we are going to drastically improve this agreement. And the person is presented the extension of, oh, hey, here, look, we just want to extend this for another couple years, or we want to extend this for a year, we want to do this, we want to do that. Oh, no big deal here, just sign here. No, remember, stop signing bad agreements. Put the pen down, pick up the phone. Call us, 570-307-0702, or call someone who knows what they're doing. Call someone else. But don't just start signing. Put the pen down. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me for All Things Marcellus each and every week at this time on this station. So I want to touch again on these extensions a little bit because I've been getting a couple calls on those in the last week or so. So you entered into whether it be a gas lease or pipeline right-of-way agreement. Company landman comes and says, oh, hey, we want to extend it. I had one the other day that we did a review and consultation on, and it was a modification, very similar to an extension, of a gas lease from 1997. So 20-year-old gas lease that they wanted to modify. And what the landman said to the gentleman, as I understand, was, well, we just want to modify this and keep it all the same, and it should be really good for you because it's on the same form that you've had, so you should be really comfortable with it. That's fascinating to me. The form is 20 years old. The form agreement, this particular person didn't even sign it. They got the property in the last 20 years. They didn't even sign it. This form agreement did not have the most basic terms that almost all offers, but absolutely not all offers, include. For example, this document, the original document that they wanted to modify to add something that was beneficial to the company, this document did not even have indemnification, meaning that if there is a lawsuit for operations on the property or any lawsuit, and that property owner was named in a lawsuit. Let's say they're building a pad. Some kids come up there in the middle of the night. They're fooling around and somebody gets hurt. They get killed. They get paralyzed. They get hurt really bad. Well, there's a darn good chance, and almost in my mind a guarantee, you as the landowner are going to be sued, as will the company and everybody else that the lawyers can sue. Now you have to defend that case. Well, now you're starting to talk about hundreds of dollars an hour in legal fees. Well, who's going to pay that? Well, if you don't have indemnification language in there, well, then you're going to have to pay it. So you need to have language that says that if there's an accident or if there's a lawsuit resulting from the company's activities that you've approved in your property, they are going to defend you, pay for your legal defense. And God forbid if there is a judgment where you're found to be liable, they're going to pay that judgment for you. That's basic stuff. However, indemnification clauses can be very complicated, so you got to be very careful with them. And of course, the companies are smart and they got smart lawyers. You should too. So they're going to give you, or in this case, they didn't have an indemnification clause. So they says, oh yeah, you should be really comfortable with this form. Well, what person in their right mind would be comfortable with a lease or a pipeline right-of-way agreement or any other contract for industrial operations on their property that did not guarantee that if they were sued, they would be defended by the company so they wouldn't incur tens of thousands or hundreds of thousands of dollars in legal fees, and that if there was ever a judgment against them, a court holding that the person, the landowner, property owner had to pay money, that the company would pay that money for them. Nobody. It's the most basic thing in the world. And that, ladies and gentlemen, that's something that really, that's part of what discourages me sometimes so badly, is that if you're sitting at someone's table and you're saying, oh, hey, yeah, you should be really comfortable with this. Well, shouldn't you tell them, well, yeah, you should be comfortable with this, but you don't have indemnification language. So you could get sued. You'd have to defend yourself. And then if the court said that you had any responsibility, you would have to pay for it. Well, why wouldn't, shouldn't they tell you that? Well, remember who they work for. Again, it's not specific. It's just general stuff. But we need to cover these things. That's basic stuff that we need to cover. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Tune in each week at this time on this station for All Things Marcellus, where we bring you the information that you need to know regarding natural gas development in Pennsylvania. So, okay, I want to switch back again and talk about, so what fired me up again, and I am fired up, is the idea when a landman says, that's the most we've ever paid. That's the most we've ever paid. And the landowner says, well, the guy said that's the most they ever paid. Well, that's the same thing that I experienced back in 2007, 8, 9, especially in, you think 2006, it's the most we've ever paid. That's the most we've ever paid. Well, within a year in cases, that number probably jumped by, hundreds and hundreds, hundreds of times. If they're paying $50 and then within a year they're paying $5,000 an acre, not a flat fee, but an acre. So if you had 100 acres and you got $50 an acre, you just got $5,000. If you had 100 acres and you got $5,000 an acre, you just got $500,000. $5,000? Because the landman said, well, we're only ever going to pay $5. That's the most we're ever going to pay. Well, all right, I'll go ahead and sign. Versus, well, prices went up, market changed, people weren't signing, whatever the conditions were. A year later, they're offering $5,000 an acre, and that person signs for $500,000. Not $5,000, but $500,000. That's what we got to remember. Now, again, I am not saying that this is how these numbers are going to go. But what I am saying is when someone tells you, this is the most we paid, this is the most we paid, this is all we're going to pay, let's not forget the past. Let's not forget the past. And let's remember, the landman works for the company, not you, the landowner. And as always, this is not specific advice for anybody. This is to get you thinking and understanding. And this is my opinion. I believe in my opinions, but these are my opinions. Okay, we're at the end of the third segment. One more to go. Remember, join me each week at this time on this station for All Things Marcellus. Been doing the show now for 7 years, and we're not close to stopping. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, give us a call, learn about representation, reviews, and consultations, 570-307-0702. Regardless of your location, I have represented clients in Canada, Hawaii, Alaska, Micronesia. You hear me say that one? That was my favorite. London, I think in France also, who have property or gas rights in Pennsylvania. So, and again, I don't care if it's an acre or if it's 1,000 acres or 5,000 acres. I have clients over 5,000 acres and I have clients over under 1 acre. So don't be afraid. We are here. My goal is to help you. And if I don't think that I can help you, and if we don't think, and I don't think I can help you cost effectively, I will tell you. I promise you. My reputation and my character I hold in the utmost, in the highest regard. So I am not here to take advantage of people. I'm here to help people. So that's what we think we do, and we think we provide a good service at a fair rate. So again, not trying to be commercial, but I know people at times think, oh, I'm afraid to call an attorney. I'm afraid to call an attorney. Listen to the show. Get to know who I am. Check out the websites. Know who we are. I am here to help you. And if I don't think I can help you, I promise I will tell you I don't think I can help you. You know, my parents raised a better kid than somebody to go out and try to take money from people. I'm here to help people, and that's what we want to do. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, and you can call me at 570-307-0702. And again, check out the websites, pagasleaseattorney.com and pipelineattorney.com. I want to talk now, and this is a bit specific, but it applies to anywhere that when you have these option agreements. So the company has to do something to exercise the option, and you should have negotiated what that event is. Is that pay you a second payment, which would be like a balloon or a much larger payment? Is it going to be just sending you a letter? What has to occur to exercise the option? And I have a suspicion that there are companies out there, and that there are examples where companies are saying to a person, oh, hey, we've now exercised your option, and now we have the right to put the pipeline into the ground. And let's say you have, and I'll use Howard Energy as an example. This is solely an example. This is not specific advice or specific situation. I'm going to go a real general example. Say you entered into a pipeline right-of-way agreement with Howard Energy, and that was a 2-year option agreement. Well, come 2 years, that company has to do something to exercise the option. And the question is, are these companies doing what they need to do to exercise the option? And if they are not doing what they are required to do in those documents, then they have failed to properly exercise the option, which would mean then that that agreement is no longer valid, which then means that you can either say, no, I don't want this pipeline on my property. You can say, yeah, you got me a couple years ago. I wasn't informed. I didn't know of my rights. I bought into the old, oh yeah, hurry up and sign. You'll get royalties and you're going to be rich. But now it's 2 years later and I'm wiser. And so now I'm going to say, no, thank you, or I'm going to negotiate a new pipeline right-of-way agreement. And perhaps I'm going to call a guy like Doug Clark, who knows what he's doing, who's going to help me, and I'm not going to have this situation occur again that occurred a couple years ago. But what is occurring, I think, this is me thinking, and I'll tell you, I've seen an example that makes me think this, but I think that companies, and we'll say companies like Howard Energy, but other companies as well, may not be fulfilling their obligation of what they need to do to exercise their options. And in the case of Howard Energy, they have this form option agreement, and it requires. So guys, if you have a Howard Energy option agreement, please pay attention. Their form agreement, I'm holding it in my hand, method to exercise the option, states that under the agreement, they have the right but not the obligation, it is their sole discretion, at any time during the option term, we'll say 2 years, to provide the option notice to the landowner how to exercise the option, which requires that they shall specify that they chose to exercise the option. Number one, that's pretty simple. Number two, attach a copy of the easement to be executed or signed by the property owner, which will contain terms substantially similar to those in the option agreement and other reasonable requirements of the company. First off, that's an insane provision, and you shouldn't be signing an agreement that has that in there. However, we'll say you did. But again, now we're smarter. Then it goes on, it says you got to then state the date that the easement is to be executed by the landowner, return to the company. Then the company has to sign it, return it back, and there's these other processes. The question is, did the company do that in your case? And I'm going to tell you, I suspect that in many cases they did not follow what I see strongly as their mandatory requirements to exercise the option. And if they didn't do what they needed to do, they no longer have a pipeline right-of-way agreement. But if you don't object, and if you don't say anything, and you don't say, hey, you don't have an agreement, they're going to operate like they do. And then if you don't bring a claim or if you don't address this, you're going to probably lose your rights because you only have so much time to object. We have to make sure that you're not being taken advantage of. We need to make sure that if your option is being exercised, that it's done properly. And I'm at the point where if you have a Howard Energy option agreement and they've recently exercised your option, call us. I will look initially for free to see did they meet those requirements. You got to send me what they did, and I'll look, and then I'll say, okay, I don't think they did, or I think they did. And then we can go from there. But I do not want people out there that have right-of-way agreements when really they don't, where the company failed to meet their option requirements. And these are serious. And I assure you, they hold you to the terms of these agreements, and you must hold them to the terms of their agreements. They can't just go sweeping mistakes under the rug when they're theirs, okay? We need to call them out. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can call if you're in for anything, but if you're in a situation where Howard Energy recently exercised an option, I want to hear from you. 570-307-0702. 570-307-0702. Because if they didn't exercise that option properly, you're in a very, very improved situation because you can say no or you can renegotiate. And that's a tremendous opportunity because if you signed that option agreement 2 years ago, 3 years ago, a year and a half ago, whatever that time may be, well, you probably weren't represented because I won't represent people who signed this option agreement because it's so bad. But if you have signed it and they failed to meet their obligations, then if they didn't meet their obligations, then that agreement no longer exists. But if you don't object and you don't raise that issue, well, then you're going to live under what I think is a really bad right-of-way agreement for you. So let's not make the mistake at the beginning and not have representation and sign these right-of-way agreements. They're the leases of 10 years ago. They're taking advantage of people, in my opinion, who are uninformed. Let's not fall into that same trap. We have the information. We have the knowledge today. Let's maximize these. Regardless of where you are, let's maximize these agreements. So, Howard Energy, if they have exercised an option for you anytime in the near future, call. We'll look at it to see if we think there's an issue, and then we'll go from there. Also, if they are asking you, Howard Energy, to extend an agreement, call. You need to do a review and consultation. 570-307-0702. Remember, everyone, we need to stop signing bad agreements. Get information that's going to help you. And remember, the landman works for the company, not you, the landowner. Give us a call, 570-307-0702, and listen each week at this time on this station to me, Attorney Doug Clark, for All Things Marcellus. Have a great week, everyone.